Hello, my name is Kaveh Williams. I'm serving on the jury in the case of the plaintiff, Casey Casepers, the patient, versus the defendant, Ashford Hospital, which will be represented by Emma Teteran. Okay, the case is the patient, Casey Casper. She was both a patient and an employee of Ashford Hospital. She alleged that her protected health information was impermissibly disclosed to her supervisor. Ashford Hospital distributed an operating room schedule to employees by email. The hospital's OR schedule contained information about the patient's upcoming surgery. Information disclosed included but was not limited to her social security number, her birth date, her age, her residence, her insurance, and her payment information, her former surgeries, her former current medications, past medical conditions, her primary care physician, her personal psychiatrist, and other health professionals that she had seen throughout the past year. The patient's supervisor was not part of the OR team or the patient's treatment team, but was considered to be in a senior administrative position within the facility. Okay, the plaintiff argues that her privacy rights were violated, and she was mentioning under the HIPAA laws that you must obtain in written authorization and consent, in which she did not consent to doing. Okay, I also agree with the plaintiff. Okay, violating her privacy rule. The supervisor does not qualify, and he had no need to have her information. She is correct of the HIPAA rule, and she also feel like her freedom of information Act was violated as well, and it gave her mental pain and distress. Okay, and we all have a responsibility under as being healthcare administrators and to protect the patient's privacy and confidentiality. Okay, now she felt that her supervisor had no medical necessity of her information as he was not a part of her treatment or her health insurance plan. Okay, defendant argues that the case was given to the supervisor. Okay, they feel like that they didn't violate any HIPAA laws. Okay, she felt like the hospital feel that they had no violation of the law was done. Okay, and they felt like if she had a problem with the supervisor, another institution should have been chosen. Okay, and I understand that, but the patient has a right to choose any hospital that she pleases, and it was probably more convenient to go to the hospital in which she worked due to insurance coverage and primary care options that she has. She does have the right to choose which hospital she wants. There should not have been any issue with her supervisor obtaining the information. The hospital feels that no violation of the law was done. Okay, now my argument towards the defendant of the case was given to the supervisor, possibly by accident. Okay, although a mistake has been made, the information was given to a senior administrator who knows about HIPAA and the patient privacy as well as not to discriminate. And they know not to discriminate about any of the information that was given towards them in regards to the patient. All right, now my argument also, based on my decision, is based on the HIPAA law and prohibits the due to the Patient's Privacy Act and their confidentiality. Okay, so according to August and Spander first 2016 article, HIPAA compliance and training to improve the efficiency and effectiveness of the healthcare system. The Health Insurance Portability Act of 1966 include administrative simplifications, provisions that required the Department of Health and Human Services to adopt national standards for electronic healthcare transactions and federal privacy provisions to safeguard the protected health information within those transactions. Okay, there's also HIPAA rules as far as HIPAA privacy to safeguard the protected health information within those transactions. Okay, now there's also a HIPAA privacy 2 and security rules, number 3, inside the HIPAA rules that are meant to ensure the protection of the protected health information while allowing the flow of health information necessary to provide high quality health care and protect the public's well-being. Okay, the plaintiff felt violated and not protected. She also felt concerns of mental pain and distress. Although an employee as well as a patient in the hospital, she should not feel this way and something should be done about it. Okay, and also in the privacy rule training requirement, it provides that training must be done for all members of their workforces on the policies and procedures with respect to protected health information as necessary and appropriate for the members of the workforce to carry out their functions. And that's according to Argus and Spandifer in 2016. Okay, now according to Brody's 2016 article, a closer look at HIPAA violations. Another revision to HIPAA rules is making business associates responsible for compliance with the HIPAA regulations. The hospital is required and responsible for knowing who sent this information and who are they sending it to. It just so happened to be an employee as well as a patient in this case, but it could have easily happened to any other patient. She did not give consent, so therefore her supervisor should not have access to her information. Okay, HIPAA has two parts, the privacy rule and the security rule. The privacy rule applies to protect the health information in all forms, oral, written, and electronic. Okay, now the privacy rule standardizes how and for what reasons our covered entities can disclose a person's protected health information. Okay, I rule in favor of the plaintiff, Casey Caspers, because the social security number, her privacy of the doctors, her history of health professionals that she has sent in the past years have been violated. There should not have been any reason for her supervisor to see or know any of this information. I agree that her health information was impermissibly disclosed. Her social security number is very private. Her medication shouldn't be disclosed to her supervisor. The ethical standards of her seeing a psychiatrist is very private and personal. He was not a member of her OR team or a patient of her patient treatment team as well. Okay, another ethical standards would be her past medical conditions. Her supervisor may treat her differently now that there is awareness of such things, bring it to the forefront in her attention. Thank you.